it was brought up to me actually from a relative of mine who's got a situation with a collection agency coming after him. And I said, you know, it's amazing how they can get control over you with a piece of paper. But it's not you that they're controlling. They're controlling an entity. An entity that was created right after you were born. Not right at birth, but right after you were born. Certificate of live birth was created. Your parents probably got you a social security number, and it began your process of contracting in the fictional world. And these things are useful tools. I mean, it's nice to be able to get a bank account and do these other things, but they all come, anytime you accept a benefit, it comes with consequences. So what I thought I'd do is I'm going to go through a complaint with you real quickly, and I want to look at the language, and I just want you to listen for the words that you're hearing, and tell me if you're not catching what's going on, because if you've been studying this a while, you should start to be able to catch what's going on. So, let me pull up the right document first. First, the actual, this is the summons he got. Now, he's sitting at home, and let's see if you can catch all the mistakes. And by the way, it's no criticism of any individual person. It's really a criticism of all of us for not knowing how to read. And of course, we're using foreign language. But let's just see what this thing says. So, in the Circuit Court of the State of Oregon, County of Deschutes. Okay, first of all, in the Circuit Court of the State of Oregon, County of Deschutes. Those words alone right there mean that when you come in, you're now in their jurisdiction just by being there. Well, that's kind of a dangerous thing to do if you're not sure what it's about. And then of the Court of the State of Oregon. So now it's of a superior corporation. Okay, so because remember, everything you're dealing with, all these states and counties of, states of, are actually corporations for profit. So let's see what happens here. So then it says Portfolio Recovery Associates LLC plaintiff, and I won't use the name of the defendant here, but it's a summons, and it has a claimed amount of 963.72. Then it has some Oregon Revised Statute 21.160 1A. But interestingly enough, when you read the plaintiff and defendant names, it's in an all capitals format. What does that mean? Well, it automatically means that those words don't actually appear. They're actually fictional words. But for the sake of this, we'll just go along with it, okay? So first of all, he calls me up and says, I feel like the world's coming down on me. The world's crumbling. Everybody's after me. And he has a couple of collections issues, that's all. And my first response to him was, well, first of all, you're responding to a piece of paper with black and white type on it that could do nothing more than cost you a little bit of money in the worst case scenario. So let's get real first, okay? Sometimes we get a little more excited than we need to be about these things. And it's written in a way with these big letters and all this stuff to sort of look scary and intimidating. Well, once you get fear out of the way, you can actually bring logic back into the equation. So it says to, and then the guy's name again, and in all capital letter bold, you are hereby required to appear and defend the complaint filed against you in the above entitled cause within 30 days from the date of service of this summons on you, which was just last week. And in a case of your failure to do so, for want thereof, plaintiff will apply to the court for relief demanded in the complaint. Man, that sounds scary. It's a lot of black and white words, isn't it? Well, first of all, let's talk about a couple of real key things on this. This is how a case is written, by the way. He who writes the case writes the law of the case. It doesn't matter what statutes or codes they bring up. That's not law. You've got to get over that. What's law is when the complaint is filed, what the words at the top of the document are the law. So until you dispute what's at the top of the document, which most people don't actually do, they just say, oh, I'm sorry, I should have paid you, blah, blah, blah. They just confess. So this whole system is designed to make you confess. Okay? First of all, nobody can give you an order. And no corporation can give a man an order. You got to understand that. That's just a rule. So it says, to, and his name, you are hereby required. Now, what's the key word in all this? Is it his name? Yeah, kind of. But it's also the word you. you is referring to the fictional entity. So if he responds in a certain way, he is granting jurisdiction just by responding. I mean, you don't want to give these people jurisdiction on anything, right? But he says, you are hereby required, so, you're just going to obey anybody that sends you a piece of paper, right? Which is what most of you do. I've done it. I'm not saying, I'm innocent of these things. Then it goes on and says, anyway, in all capital, notice to defendant, read these papers carefully, ! You know this was written by their attorney. It wasn't written by a court. You must appear, and it says appear in quotes, in this case, or other side to win, or the other side will win automatically. To appear, and it puts it in quotes again, you must file with the court a legal paper called a, quote, motion, and, quote, or, quote, answer. The motion or answer must be given to the clerk or administrator within 30 days along with required filing fee. And that's within 30 days of the delivery of the document to you. Don't be fooled by numbers. They intentionally write earlier dates on these documents to fool you. It's 30 days from the date of service, which it does say in the upper instruction. But they try to fool you by putting other different dates on these things, so read carefully. And know your local statutes, because when you are replying, you're doing it under statute. The motion or answer must be given to the court or clerk or administrator within 30 days along with the required filing fee. So now it says, here's how you reply. Okay? It must be in the proper form and have proof of service on plaintiff, lawyer, or plaintiff. If plaintiff does not have a lawyer, proof of service upon plaintiff. If you have any questions, you should see a lawyer immediately. If you need help finding a lawyer, yada, yada, yada. So, and then it puts it, the date was January 21st, 2015 on here, but he only got it last week. Now, you'd normally look at this and go, oh my gosh, 30 days has expired, I'm done. I'm not going to show. And that's the trick that they use to get you not to show. They make you almost, if you don't read carefully, they make you believe that you've already lost before it began. Now, he does need to file a motion to dismiss for failure to state a claim for which relief can be granted. That's all he needs to file. And he'll send it to the plaintiff. We'll have to look up and see if there's a filing fee or anything like that, but he definitely needs proof of service, and you'll have to check with the court to see what their proof of service requirements are. I don't tell people what it is. I tell you to go look it up. In this case, it's probably just to have a process server send it to the company. They don't even put their address on here to make it really hard to find. They do everything they can to try to slip you up. But anyway, so he could send and I know in our state, for example, services also, you could send it by U.S. mail first, then follow up by just a certified mail, and get yourself a receipt, that something online or a card that's sent back to you. And then, but see, these are designed that you don't respond. And it is in fact a truth that 90% of the people never respond to this. So what does that mean? You lose. Silence is acquiescence. People seem to have a hard time getting that concept. Well, you should understand this. If you don't respond, your silence is your agreement. That's acquiescence. And so people do it to themselves all the time. And then they come screaming to somebody like me or somebody I know who helps people and say, what do I do now? I said, well, turn back the clock and respond by the deadline they gave you. Read the darn document. I mean, it's like people don't go to school and can read anymore. It's really, they tell you exactly what you got to do, and just check a few things, and you can call the court clerk and say, hey, I'm not sure how I should answer this, but do I have to file it here? Well, it says here you need to send it to the plaintiff. Well, I would send it to the plaintiff and to the court. See, they don't tell you that. Here's the rule about who to notify. If you're not sure, notify anybody you can think of, because if you can under-notify, you cannot over-notify. So yeah, send it back to the party that sent it to you, and send it to the court and talk to the court about if there's any fees you're required to file. That's all you got to ask. It's not hard. A phone call will get that done. And it's for $963. It's not a fortune, but maybe to this fellow it is. Maybe he works, week to week, and he sometimes has to struggle with making the bills. So it does become a big deal. It's a big deal for everybody. But here's the bottom line to this whole thing. When has anybody ever said prove it? Okay, prove it. First thing I'd be asking the guy is, well, first of all, you're making a claim against me. I need to see your bond. They don't like to be asked for their bond, by the way. Don't forget that. You might be wanting to answer and say, or a motion to dismiss for failure to state a claim for which relief can be granted. That's a standard motion. Again, we're not getting into the common law stuff yet here. I just want to get a motion in and stop what's going on. Okay, so first thing is stop, then take the time to get yourself set up. And, your motion is to dismiss because you don't know who these people are. They've never brought forth a contract. And you would probably put in the motion where you'll require that anybody coming forward to the court will have to have first-hand knowledge to the contract and be willing to testify. That should be in your motion. Now, they might ignore that to a certain degree, but they really, as long as you respond, believe it, you're in the top 10% just by responding to these things. Because most people just freeze up and let a piece of paper with black and white ink on it stop them from thinking. Even talk to somebody, just read it over with them and say, what do we do? Oh, call a lawyer. Come on. It tells you exactly what to do on here. And by the way, another thing you always have to remember, this is a biggie. Everything they send you is not, no matter how it's worded, you are hereby required and all this stuff, you must appear. What do you mean appear? Am I genie pop out of the bottle? What do you mean by that? These words are kind of tricky. But everything, remember this, everything the judge says to you, everything they send to you, everything they present to you is an offer, which you can refuse. Or, if they have a UCC law on this, if you've refused within 33 days, you just send it back, refuse for cause, refuse to contract. Write all over it and send it back to them. Nothing fancy. As long as you do it within, per UCC 1-308. So you send it back. You did not contract. If it's been longer than 3 days, you still can. You do that, but it's not as effective, generally speaking. So you want to refuse it. Or, if it's after the 3 days, you can simply write in your motion or a letter back, I conditionally accept your offer upon proof of claim that you'll bring forth the original contract with all the parties that signed it and have them testify under oath. And if you will not produce that, then I consider your claim to be a false claim, subject to liability on your part. Please produce your bond for sending me a false claim. Believe me, you just took over and you made a new contract by responding. But if you don't respond, it's their contract. That first paragraph where it says, you are hereby required to appear to defend the complaint filed against you, yada, yada, yada. That's the whole contract. There is no other contract, you see. They're going to come in here and say there's some other stuff that this other company you borrowed money from, yada. You stop the attorney right there and say, wait a minute, sir, do you have first-hand knowledge? You need to learn how to shut down attorneys. And it isn't that difficult. You simply say, do you have first-hand knowledge? Because everything you're saying is hearsay. I object. You're putting hearsay on the record. By his own statements, and even coming into the court, he's putting hearsay in. You need to stop that. Object. Say hearsay. That needs to be stricken from the record. Whatever he said. Now, again, the tricky part of this is, though, it's their contract. It says you are hereby required to appear and do yada, yada, yada. Well, guess what? That's true until you stop it. So, your response helps, but you're going to have to do one additional thing, and that's what we've been teaching you for some time, and that's how to file a claim. Because if you don't file a claim, you're moving on their contract, not yours. Would you rather be the one that writes the contract for the court or let them do it? Because that's all we teach. When it comes to the contract thing, the claim process, it's a matter of starting a new contract. And now it's your contract. You see? That's the difference. And as long as they're sending you papers, you're moving under their contract. Do you think they're going to write a contract to favor you at any point of the process? No, which is why you lose 98 or so percent of the time. 90% of the time people lose because they just concede, but 98% of the people lose still because they don't understand that the only law that's before the court is the document, the contracts that they're submitting. And you really don't have an option to say much. You can defend and fight and argue all you want. But the simple fact is, you're forgetting the fact that their law is what's in the court, not yours. They don't care what you say. Let me read the next document. You'll start to get the idea how this is starting to work. So they send another thing called a complaint, breach of contract. This was actually accompanied it, but it says, plaintiff asserts the following claims for relief against defendant. Now, first of all, are you a defendant or are you a man? Because a defendant is something on a piece of paper. If you don't get that, you're not going to have much of a chance of getting this. And it says it's a complaint, breach of contract, subject to mandatory arbitration. Oh, there's a contract. Boy, I'd love to see that. So they start off by saying jurisdiction and venue are proper. Well, is it? You're just going to assume that's true? Well, they said so. The guy's an attorney, so he said it is. This, I'm telling you, I can't how many people do that. Jurisdiction and venue are proper. Plaintiff is a lawfully organized business engaged in interstate commerce. Now, who regulates interstate commerce in this country, by the way? I hope you're all there paying attention to your civics. It's Congress, which means once it's in interstate commerce, okay, they're saying that they're allowed to engage in interstate commerce and use the federal court system. And even though this is a state court, it's still the federal court system overall. They're all linked together. So he's saying, the plaintiff is lawfully organized business engaged in interstate commerce. So they're saying who they are. And they have a right to use the court system. That's what they're saying. Defendant resides in the county in which this action has been filed. Now, this is an important word. Every word matters. Defendant. First of all, if you're even acknowledging being the defendant, you've already given jurisdiction, and now you're the slave. See, when you go in and start arguing, you're lost at hello. And they use the word resides. This is a huge word, resident. You better not be a resident of anything that's within the domestic territory of the United States, and that includes the states where they claim zip codes over. You reside in that zip code. Well, guess what? You're subject of the state. You're of the government. You're a citizen, and so they're saying all this very important stuff. You're saying you're a defendant, and that you reside in that county where the action has been filed. And by the way, they're basing that on your address that you use. And guess what? An address has what at the end of it? A zip code. That zip code is a federal zone. So even though you don't live in District of Columbia, and you say, well, all their laws only apply to District of Columbia, that's true. And to their territories, which are zip code zones. See, that's the tricky language. Now, that's all a presumption, but you see, you proceeded allowing all this to go on, which is why you confessed before you even got started. You can fight all you want, but you already said, I am a defendant and I reside there, and citizens have no rights. You got to get that. It's not like they taught you in school. So anyway, first claim of relief, breach of contract. Defendant was indebted to GE Money Bank, all capital letters. Okay, it says you're indebted to a thing. But since you're coming in as a defendant and you're agreeing you're a defendant, then the contract, here again, this is contract. Oh, that's the contract. Here and after the original creditor for credit extended to defendant. Under the terms of the agreement between the original creditor and defendant acquired merchandise, services, cash, or advances through the credit, and the original creditor performed its obligations to defendant by providing the credit as agreed. Well, folks, if you've been doing any research in this area at all, actually, it's your own fault that you don't understand this. I mean, it is, because you should have tried to learn this when you were younger, but here's the issue. You are the creditor. So they're saying the original creditor mailed statements to defendant. Now again, if you go in and try to argue this, the problem is you're arguing as a defendant. Again, you already agreed in the first paragraph that you are a defendant and you're the debtor. Defendants are debtors. There can't be a creditor and a creditor here. It has to be a creditor and a debtor. So if you assume the role as the debtor, then they are obviously the creditor. You see, you can't argue against this stuff unless you move your own claim under the rules of common law that we teach. So all this other stuff is just filler, okay? Bottom line is they had you at hello. You're a defendant? Oh, yeah, okay, I'm a defendant. I'm responding. I'm going to fight this. That's the wrong approach. And if you hire an attorney, you've automatically taken that approach. And let's see, last paragraph. And then at the end it says, wherefore plaintiff prays for judgment against defendant for the following amounts. The account balance of $963, less any payments made, interest post 9% per year till paid, plus court costs and any other relief for the court deems just and equitable. And of course, If you fight this and lose, what they're saying is you're going to pay more than that because you'll be paying for their attorneys too. Geez, it might be just cheaper to quit. Or, what if you went in there under small claims and filed a $50 small claims filing claim using the process we give you, the one page. I, man, say that you are making a claim against me. You're making a claim against my property. Come forth and prove your claim. I mean, that's essentially all a common law claim is. A little bit longer. If you're in the advanced members area, you can get the document that how you file it. But I would get the quick motion and answer in just to stop this process. It's just nothing. It's very simple, and then get a motion, anything in. That's all. That's the key. And then go in and file your claim, which is a new case, but you can file it right into this case. You can say, here you go. My claim now is on top of this case, and it's like a counterclaim now. Okay, we don't call it a counterclaim, just call it a claim. It's real simple. Use that simple 1.5 page document that we have in the advanced members area for a claim. And it looks kind of weird because we don't talk about any of the stuff they're talking about. We talk about you're making a claim against my property, and I'm a man. Where do you get a right to make a claim against a man? And they don't. They can't. And once your claim goes in, you're going to require them to bring forth a living man who has first-hand knowledge of the contract, who will swear to it under oath. And that includes if that attorney wants to speak, you need to stop him on the spot and say, wait a minute, you're entering hearsay, you're reading stuff, you're putting documents in, that's all hearsay evidence. I want it sworn to under oath. Please put that attorney under oath. And he probably won't want to do that because he probably just showed up 5 minutes beforehand and they handed him the papers and said, go in there and get this judgment. Because they know that 98% of the time the people are just going to walk away. And I told my relative, I said, if you just show up, you do a motion and you put this claim in, at least your chances are now in the top 5% of winning. I can't guarantee you'll win. You have to do a little extra work. But it's the concept and the procedure. Because your case sets a new contract. And a contract by a man always supersedes and stands above fictional contracts by corporations. Because who creates what? Man stands above the corporation, right? Man stands above the government. So your claim is not a complaint. Theirs is a complaint. Complainers and whiners complain, but men claim. And you need them to come and bring a claim by a man, which they won't do. So you see how they might get stuck if you file a claim, a 1-pager, 2-pager? It might just kill a case like this pretty easily. They're not going to push very hard, spend a lot of money chasing $963. Now, on a mortgage, where there's a secured interest in question, which you can deal with in a more advanced way, that's different. But in an unsecured credit like this, that's the whole process. So whatever they're throwing at you, don't get too